Nice to see you both. This is the final case of today's case call, Doster versus Covenant Medical Center. It's a 15-minute mini oral argument on the application. Mr. Kelly, you may reserve some of that time for rebuttal, but we ask you to try and keep track of it yourself. And if you are ready, you may proceed.
Thank you, Your Honor. I would like to try to reserve 3 minutes. May it please the court, Kevin Kelly on behalf of the plaintiff appellant, Ms. Doster. This appeal raises 3 important questions, but I'd like to focus on the last issue, whether a factual question existed regarding pretext based on the record before the trial court when it ruled on this dispositive motion, as this court requested supplemental briefing on that issue. The defendant did not challenge plaintiff's ability to establish a prima facie case of age discrimination. So we start from the position that there's a presumption of discrimination. At this point, the defendant must articulate a legitimate non-discriminatory reason to rebut that presumption. The Court of Appeals and the defendant, in its answer to this application, stated its alleged legitimate business reason was that plaintiff lacked required consulting experience. So to begin the pretext analysis, I think we should look at what evidence is there that the defendant required consulting experience for the job. The best evidence of that would be the job posting. It lists the minimum requirements, both required and preferred, an applicant must possess. But nowhere on the job posting does defendant require consulting experience. The failure to list consulting experience permits a negative inference that no such requirement exists under MRE 8037. Courts have further found that basing a hiring decision on a qualification not listed on the job posting raises a genuine issue regarding pretext. So for instance, in the Courtney case cited by the plaintiff in their brief, Seventh Circuit found, quote, a reasonable juror could conclude that the employer would have included this qualification in the job listing had it honestly believed that it was of primary importance for the new position, end quote. Because of this evidence, the Seventh Circuit concluded reasonable minds could differ as to whether the employer's emphasis on that particular qualification was a pretextual explanation for not hiring the plaintiff. The same reasoning applies with equal force in this case, where the employer never mentioned consulting experience as a requirement for the job. So I think at that point, right there, we can end the analysis. There was sufficient evidence for the trial court to conclude that the proffered reason was pretextual. Although it's not necessary to go forward, we can still look at the job posting to see what were the minimum requirements. One of those requirements was that the applicant must have recruiting experience. We know that the plaintiff had well over a decade of experience as a recruiter, and she was familiar with Covenant's applicant tracking system, another requirement for the job. But did the successful, substantially younger candidate, Mr. Ruddy, have any experience? The only evidence before the trial court was Mr. Ruddy's resume, which states that while he worked as an assistant, he, quote, assisted in recruiting. The lack of any further evidence of recruiting experience should raise a genuine issue as to whether Ruddy had the required recruiting experience. What inferences can we now draw from that? Well, under the relevant case law, where one candidate is the plainly superior applicant, which means that that applicant meets all the qualifications and the other one doesn't, a fact finder can infer pretext. So here you have one candidate, the plaintiff, met all the minimum job requirements, while the successful candidate, Ruddy, did not. That permits an inference of pretext.
Mr. Kelly, let me interrupt you, and see what questions folks have. We can get back to you if there aren't any. Justice Zahra.
No questions.
Justice Viviano.
No questions. Thank you.
Justice Bernstein.
Hey, counsel, I'm going to kind of pitch you an easy question just because I want to kind of see what your thoughts are on it. But it just feels as though, and if you could elaborate, it just feels as though the Court of Appeals seemed to kind of go out of its way to try to overturn a verdict that was made by a jury.
Yeah, I agree 100%. I think that if you look at the court's analysis, there's not substantive discussion as to why a particular piece of evidence cannot lead to an inference of pretext. It's a mere labeling, hey, this is speculation. We don't need to consider it anymore. We're not going to explain to you why it's speculation. You're done. And I think that does quite a disservice to the judiciary because we're supposed to be impartial here. And how do we show that we're going to be impartial? But by analyzing the evidence, giving reasoned opinions as to that, copying out by just labeling something as speculation and moving on is just creating a facade of impartiality without actually backing it up. And so I think there was significant evidence here that the court could have upheld the verdict.
Thank you, counsel.
Justice Clement?
Thank you. So of the three issues that have been raised, are there any one over the others that should be taken into consideration, or is it all three together that would allow the plaintiff to go to a jury trial here?
Well, yeah, I do think all three of the issues could reverse the Court of Appeals and allow the jury verdict to stand.
Individually, any one of them, or do we need to look at all three of them together? I'm trying to get a sense from you if there's, if you think it needs to be all three, or if you would prioritize them as far as which of them gets us to a jury trial.
Yeah, I think all three independently do. I think they all relate to each other, surely, because I think there's a relation between the first issue as to whether they have jurisdiction, right? Well, why would you want, you're sort of ignoring the fact that we're developing the evidence later. You're getting a more complete record by looking at the trial, right? That relates to the second issue as to should we look at the entire record, right? The whole idea here, I think those two sort of feed off of each other, is that we're trying to find the truth. And so we should look at all the evidence. If we don't allow this type of limited appeal of one particular issue at an interlocutory stage after the fact, after we've gained additional evidence or have a more perfect record, right? We're looking at more evidence, we're taking that in. Same thing as if we look at, as an appellate court, look at the record, the entire record as to what happened in the trial court and reviewing, you're looking at all the evidence, you're trying to make that pursuit of finding the truth there. So I think those two relate. Do you have to do one or the other? I think no, both get us to the end. If they cannot appeal because the Court of Appeals did not have jurisdiction, the interlocutory order on the denial of summary disposition, then the Court of Appeals couldn't enter that order. They would have had to consider the other issues post-verdict, motion for JNOV, those type of issues. If we look at the entire record, I think even the Court of Appeals agrees that there's sufficient evidence at the trial court or at trial in the testimony to support the jury's verdict. So analyzing the sufficiency of the evidence based on the trial record, if that's included, I think gets us there too. But I think probably the easiest solution here is to look at the record that existed then in front of the trial court and find that there was sufficient evidence there to find a question of fact, because I think there was.
Let me interrupt you real quick. I appreciate the answer that you just gave. Maybe my question wasn't clear enough. Although I appreciate what you just said, because I think that's also very helpful. As far as our framework of proving the prima facie case, and then the defendant producing a non-discriminatory reason for their decision, then the plaintiff has to produce evidence that it's mere pretext. Of the three things that I see that have been raised, so we've got the change in the reason being the consulting experience, the change in the scorecard, and the notes regarding something saying young and then respect and that. Of those three things, do we need to look at all three of them to show that the plaintiff produced evidence that is sufficient to get to a jury trial? Do any one of them independently get us there? Talk to me about those three.
Oh, yes, sir. I didn't miss it. I didn't miss it.
Okay.
I think we're supposed to look at all the evidence together. So I would say, first of all, we should look at the entire record there. All three of those issues, they build off of each other. That's how circumstantial evidence works. Is it necessary? I would think that that's probably a harder question that we don't necessarily have to reach, but no, I think you can look at, there are cases that say you can infer a question of fact on pretext just from the inconsistencies with the reason for the adverse action. So the fact that they're basing it upon a requirement that's not listed on the job description, I think that alone gets us there. I think, yes, the issue, the notation about being young, if you look at that in combination with the other notations that Ms. Hennigy made, asking or finding a positive attribute that the younger candidate was looking for leadership in the future, right? Obviously, an older 62-year-old employee is not going to be able to have that luxury of trying to climb through the ranks. Looking at, asking Ms. Doster, why apply now? I think you see a pattern there of these notations showing that she's considering age. I think that in of itself should raise a question about her motivation. But again, I think, that just those inferences we're drawing is just becoming stronger when we consider all of that together. And certainly when we look at all of that together, I think there is a genuine issue of material fact.
Thank you.
Justice Cavanagh.
I'm going to piggyback on that a little bit. So I understand, let's say that we agree that there is, that the scoring process was, wonky, for lack of a better word, and the job posting, didn't accurately reflect. I'm not saying that the record necessarily reflects that, but let's say we agree with that. Why does assuming that to be true allow us to draw an inference of age discrimination? In contrast to the statements, I think what the trial court was saying, the notations, of young and why now, require an inference that could go, an inference that it means age was being considered, or it could mean an inference of the ability to rise through the ranks and, why does she want to leave her old job, non-age related. But if you're choosing between inferences, that's a jury's job. Why do the other theories of the scoring and the job posting, even assuming them to be true, why do they give rise to an inference of age discrimination?
Well, I think it's distinguishing the different ways that one can go about proving pretext. And I think they're complementary, but let's look at the first method, right, is does this reason have a basis in fact, right? So that's the first way we can show pretext. Well, if we show that the reason, i.e. that consulting experience was not required, as they claimed, is not true, it doesn't have a basis in fact. The job posting lacking such a requirement would be evidence that their reason is not true, it's not based in fact. So under the first method of establishing pretext, that's what we have to do. There's no further requirement that we have to show more evidence. The second way of showing pretext, I think, is, did it actually motivate them? So I think that's, you're looking at, right, the comments. Is what they're saying what really motivated them? Because the comments suggest to, I would say, a reasonable trier of fact that no, age was on their mind. It might have made a difference in the decision-making process. I think the same is true about the irregularities in the scoring process, right? You're treating the younger candidate more preferentially. So although it doesn't have something necessarily overtly referencing age, like being young, comment does, it does show preferential treatment to the younger or the person outside the protected class. So I think that goes to the question of, is the employer, Ms. Hennigy, actually motivated by the reason she's saying she is? So I think, can we use either one? Yes, we can. And we shouldn't be limited to one way we prove it. It's just different types of proof. And I'd say all of that is sufficient under the test that we're required to establish a genuine question of fact.
Okay, thank you.
Justice Welch.
I have no questions. Thank you.
Do you want to reserve 58 seconds? Whoops.
Sure.
Okay, you may reserve. Mr. DeRozier.
Thank you, Chief Justice McCormack. Good afternoon. May it please the court. Philip DeRozier, appearing on behalf of Covenant Medical Center. We think the court should deny leave because the Court of Appeals properly determined that Ms. Doster failed to present sufficient evidence to allow a reasonable jury to find that age discrimination was a motivating factor in Covenant's decision to hire Mr. Ruddy over her for the HR generalist position. Covenant's HR manager, Allison Henage, testified that she hired Brent Reddy over Ms. Doster because of his superior consulting experience, and she determined that that made him a better candidate. Ms. Henage and the other Covenant employees who interviewed the candidates all explained that consulting experience was more important for the position than recruiting, and that Mr. Ruddy had that experience while Ms. Doster did not. This was also borne out during the interviews. Sandy Haley, Molly Andrews, and Lisa Killey all took notes reflecting how Ms. Doster did not have a good grasp on the consulting part of the job while Mr. Ruddy did. In response, Ms. Doster has offered no evidence from which a jury could find that age discrimination played a role in the decision to hire Mr. Ruddy. Instead, she relies on what we see as ambiguous statements in Ms. Henage's interview notes, alleged scoring discrepancies on the interviewer's evaluation sheets that don't in any way suggest age bias and that did not affect Ms. Henage's decision in any event, and an unsupported claim that the job posting did not include consulting experience as a requirement when it absolutely did. Nothing that Ms. Doster points to undermines Ms. Henage's explanation for why she hired Mr. Ruddy over Ms. Doster, or in any way supports a reasonable inference that age discrimination was a motivating factor in Covenant's hiring decision. I think it's important to keep in mind here that an inference is not a suspicion or a guess. Although the jury is certainly entitled to draw reasonable inferences from the evidence, it can't speculate. But that's precisely what would be required here, as the Court of Appeals properly determined. In the end, Ms. Doster's claim simply invites a jury to second guess Covenant's business judgment, which is not permitted. And I have some things I'd like to say about the specific evidence that Ms. Doster has cited, but I think I'm at the end of my fire-free zone, so I'm happy to stop and answer questions.
Let's do that. You'll probably get questions that'll allow you to say that stuff, and if not, we'll get back to you.
Have a feeling.
Justice Zahra.
No questions at this time. Thank you.
Justice Viviano.
No questions. Thank you.
Justice Bernstein.
Hey, counsel, thank you so much for joining us. I have no questions for you today.
Justice Clement.
All right, I've got one. So when we're looking at the actual job description, can you walk me through what was posted and where this requirement for consulting experience can be gleaned from that? And the reason that I'm asking that specifically is because I see the words previous recruiting experience required, but I don't see the actual words regarding consulting used. So I'm asking, like, where in there we're supposed to glean that from?
Sure. Justice Clement, I'm happy to answer that. I mean, you really hit on what I think is the key. It's not a matter of the fact that the job posting didn't use the word consultant. The important thing is that, while it does reference developing recruitment strategies, and we attached, both of the job postings that I'm about to refer to are in our appendix. So if you look at the job description for the HR generalist position, every single listed responsibility there comes right from the job description for the HR consultant position. And so if you look and compare those two job descriptions, sure, the HR generalist position doesn't use the word consultant, but like I said, other than the reference to recruitment strategies, which comes from the recruiter job listing, if you look at the HR consultant position, the job description for that one, every single responsibility matches identically the job description there. And so I think if you do that, it's apparent that recruiting and consulting experience were listed in the job posting, maybe not using the word consultant. And also you'll see that there's more of an emphasis on consulting, which is consistent with what all of the Covenant witnesses testified about, that consulting experience was what they were looking for. It was more important for this new generalist position that was created, and that Mr. Ruddy was better qualified than Ms. Doster in that regard.
Okay, and then this may be a dumb question, but what is HR consulting?
So as I'll try to encapsulate it.
Not what's listed in the job description, sure. But what it is that they were looking for. Yeah,
it's more as opposed to a purely someone who acts in what we all appreciate as a recruiting position. It's more of a focus on working with the various business units, with executives to help negotiate HR issues, to deal with labor issues, to work with outside counsel, those kinds of things. That's what the focus of an HR consultant is. It's more of an expert in someone who understands employment law, who interfaces with federal agencies, whereas a recruiter, it's literally, that's the focus, is it's bringing in talent into the company. So the consultant position is much more focused on actual HR management.
Okay.
If that helps.
Okay, great. Thank you.
Mrs. Cavanagh.
Sure. Hi, Mr. DeRosier. I'm wondering how, even if I were to agree with you, that the inference that might be drawn from the particular comments, young and why now, are weak. Why isn't it? It's still an inference, right? And so why is it not sufficient to submit that to the jury to decide, right? It could mean this, it could mean that they were improperly considering age, or it could mean that they were considering these other factors, or that they're really reflective of something. And I presume that trial counsel made that argument to the jury, and the jury still found the other way. I get that we're in sort of a weird, Michigan's a little weird, and we could, that's not really what's at issue in this case, in that your summary disposition record still survives after a jury verdict for appellate review, which is, not the case in the federal system. But so we're limited to the summary disposition record. And the trial judge said, look, I might not believe it. It may not be an inference that I would draw if I was sitting on a jury, but it is an inference that it is age related. So why does that not get to the jury?
Well, Justice Cavanagh, I appreciate that question. I think you are, getting right at the heart of this. I think that the question ultimately is it a permissible inference? Is it a reasonable inference from the evidence? So, for example, taking a note where, Ms. Hennig refers to Mr. Ruddy commenting about being young. Well, number one, you have to look at the context, right? So her entire note also talks about how it was in the context of it took a while for him to gain the respective leaders. So focusing for a minute on say that comment, the question is, can a jury draw a reasonable inference that is indicative of age bias? It's not just a matter of, well, could a jury, happen to find that it does? Well, here, and we don't know, of course, what the jury found ultimately, but we also think that's why it's important that, the trial court needed to act as a gatekeeper here. And that's what the Court of Appeals corrected. It's that when you have evidence that's submitted that doesn't allow for one or the other explanation to be granted credence, then what you have in that situation is speculation or conjecture. All the jury can do is guess. There's nothing about the evidence that Ms. Doster has pointed to that would allow a jury to reasonably draw an inference of
You don't
age.
think the word young is a reasonable inference to infer it's something about age? It's not like they said he has a blue sweater.
Sure.
They said young.
Well, but
that by definition, at least in the realm of looking at age.
I think it's clearly a reference to the fact that Mr. Ruddy mentioned being young, but I think you also can't look at it in isolation. And, you also have to keep in mind that at the summary disposition stage, all we had was the note, but the note, it had further context to it. And I think that is what, creates a problem as far as trying to draw an inference from the fact that she used the word young. It doesn't mean that age was a motivating factor in her decision. I think that's really kind of the key. It's not enough to just say that, well, she wrote the word young and the jury can make of that whatever it wants. I think that's exactly what the jury's not supposed to do. I think it's supposed to be a reasonable inference that's drawn, and I don't think that can be done here.
Okay, thank you.
Justice Welch.
No questions. I think Justice Cavanagh covered what I was going to ask, so thank you.
Mr. DeRosier, I'm struggling with the line between speculation and reasonable inference. It feels really squishy to me. Can you make it objective and less squishy for me?
Sure. Well, I'm going to try because I agree with you. I think we're all at that same point of where I think this all turns. The way I see it is that if you have two plausible ways, or there has to be something that tilts the balance. If there's just you could say, well, it could be looked at this way, it could be looked at that way. Then I think those things, it's kind of analogous to really causation, right, in tort cases. I think that if you have to have the evidence be able to make one of the explanations be the plausible one to the exclusion of the other. Because if you don't have that, if you just have equally competing possible ways to look at something, then I think that's what is conjecture. I think that's what is a guess. And so, I think it's not always easy to determine, on a given state of evidence, whether it is speculative or not. I mean, I do see that as being ultimately what the test requires. Is there something that allows you to sort of, break that tie?
Thank you. Additional questions for Mr. DeRozier? You have 3.5 minutes. You may use it.
Okay. I guess I wanted to just do a couple of things. One, I just wanted to correct some numbers in our brief. This, at pages 28 to 29, and this just goes to what I think Justice Cavanagh described as she characterized it as wonky scoring. I just wanted to point out that the numbers, I made a mistake in when I was looking through the evaluation sheets and sort of counting up the discrepancies. I just wanted to clarify that Ms. Haley did have one question that she didn't score for Ms. Doster, but she also had two that she didn't score for Mr. Ruddy. And then Ms. Henage and Ms. Killey, they each had one that they didn't score for Ms. Doster, and Molly Andrews has two. But I think, even looking at these scoring sheets, I think it takes us back to the same point. Regardless how you parse the evaluation sheets, how they were scored, nothing about it leads to an inference of discriminatory animus, which is the key here. There has to be evidence of that in order to survive summary disposition, as opposed to simply reflecting Mr. Ruddy's better performance during the interview, which is what all of the interviewers testified to in their depositions. And then when it comes to the scoring, the other thing I think that's important to mention is that the decision maker here, Ms. Henage, she testified that she didn't go through and tally up the scores. She reviewed the evaluation sheets for their notes. And so in our view, there's no evidence at all that the scoring even had any bearing on her decision. And so, so I wanted to just kind of touch on the scoring. I think we sufficiently covered the job posting and the statements, although I will say, the other couple of statements that Mr. Kelly discussed, the question about why apply now, Ms. Henage referring to what Mr. Ruddy described as a career ambition, being interested in leadership. Again, those things on their face, they're innocuous. And so the question is, what is it about those statements that allow a jury to draw a reasonable inference of age animus? And, so like I said, with all of the other evidence, I think whether you look at it combined, whether you separate it, as I think Justice Clement was getting at, I think all of it amounts to speculation and guess, and none of it allows for a jury to draw a reasonable inference of discrimination. And so with that, that's all I wanted to say, and I appreciate your time.
Thank you very much. Mr. Kelly, you had a few seconds left.
Yes, I'd just like to quickly say that the discussion about what an inference versus speculation is completely throws the standard of review on its head. Okay, speculation is when you make a guess about facts. Inferences are a conclusion you draw from multiple pieces of facts. And there might be more than one inference that you can draw from the same set of facts. It's not a preponderance of the evidence. Is it more than 50%? On this standard, you draw it in my favor because I'm the plaintiff. I'm the non-movement. So if you can draw multiple inferences, you pick the one that is most favorable to me. You don't say, oh, we should weigh this out. Which is more reasonable, which is not. You pick the one that's most favorable to the plaintiff. That's black letter Michigan law. The problem with the notes, Ms. Henage is the only one that wrote down being young. So why didn't anybody else? Why didn't anybody else write that down? That's something that needs to be explained, that the defendant has never offered an explanation of. and is something we can infer that it had to be on her mind. Why would she record that down unless she thought it was important when no one else did? Unless they were smart enough, hey, cover our tracks, don't create evidence that you're considering age. Thank you.
Thank you very much, Mr. Kelly. Thank you both. The case will be submitted. That concludes today's case call. We will be back here tomorrow. Thank you all.
Thank you, Your Honor.